Hello, podcast listeners. We know podcasts are a great way to catch up on a program that you may have missed on KSJE, and it's provided as a free service of this radio station. But, KSJE is now listener-supported, and so while you enjoy this podcast, we hope that you'll also take some time to join KSJE. Become a member today. It's quite easy to do. Just go to our website at ksje.com/support and pick the level of support that best matches your budget. Thanks again for listening. Here's your podcast. His lengthy career in behind the bench as a judge, district court judge retired, John Dean is with me. And Judge Dean, thank you for coming in this morning.
Hey, thanks for having me, Scott.
You bet. I appreciate you agreeing to sit down and talk a little bit about your career, which is kind of a long one.
16 years and 16 days.
Right.
But I'm not
that you're counting,
no.
Right? No. But recently resigned as district court judge in February. And still spending a little bit of time behind the bench, though, now.
Yep, February 19th of this year, I resigned, which was the 99th anniversary of my grandfather getting his law license.
So that was an important date for you.
It was an important date for me. It wasn't the end of a pay period. It wasn't a time that anybody liked, but that was the day I decided to do it. I had tried to go to 100, but I had decided that I wasn't going to make the last year. Both of his older sons were lawyers. My Uncle Bill practiced for more than 60 years, and he told me when I got my license that if I stayed on till that date, there had been deans that had been lawyers for 100 years. So I'll keep my license.
Okay.
And I'll make it 100 that way.
Very good. And but now you're still behind the bench for a couple of cases. One case right now, I guess, and you're filling in where you can to help out.
Right. Strangely enough, is right after I retired, a judge in Grants resigned on about 2 weeks' notice. And that's a very isolated district, a one-judge district, and it's part of the 13th, which is 2 other counties. They asked me to come down in a couple of days a week just to make sure the time limits were met. So for 17 trips, I drove back and forth to Grants every day.
Wow.
And the trip across 371 is quite nice early in the morning on a cold day, but it got a little old.
I would think so. Well, anyway, you're here with me today to talk a little bit about your career and about judges in New Mexico, and I want to ask you a little bit about that and your career, which stretched from, 2003 to 2019?
Yep, that's
pretty much, right? And before that, you were an attorney?
Before that, I was a lawyer. Been a lawyer since October of 1977. I did 9 years as the domestic violence child support hearing officer on a part-time basis, so I really spent 25 years hearing cases, and quite frankly, after I didn't have to hear domestic violence cases as a district judge, I thought I had retired then because they're tough.
There's a lot of them too.
Yeah. There's a lot of them, and it's tough.
Yeah, and you survived and went through 2 retention elections as district judge.
I did. So I would have
2008, 2014.
Yeah, I think so. I got interviewed a lot. So every time you do that, they do a pre-interview about 2 years before, and then they do an interview late the year before. And I did one more, but I told them I was leaving, so I didn't participate much in that interview.
That was it, right. And then you were chief judge just for a while here in the 11th Judicial District.
Chief judge for 5 or 6 years.
Okay. And that's dealing with the budget and some of those other administrative things?
Right. There's a chief judge in every district, and they act as the chief judge's counsel. They're an advisory council to the Supreme Court. The Supreme Court really is in charge of the judicial system in New Mexico, but they let us talk about our budgets and all of that. The courts are very unified and try to take care of each other. They're very different. I think 75 to 80% of all the cases in New Mexico go through the 2nd Judicial District in Albuquerque. So the other, if you think about it that way, only 25% go through the rest of us. And then if you think that in the 10th there's only 1 district judge, in the 2nd there's 24.
Wow.
They're very different. Courts are not the same.
No, very much so. And of course our district is so unique because there are courts in Gallup and then courts in San Juan County and Grants, as you mentioned, too.
Yep, so we've got, we have our own challenges in the 11th because we're 122 miles from Gallup. Those courts aren't alike. They have 3 district judges and 6 of us, I don't even remember, 5 of us.
Right.
And recently, since I've left, the district courts have taken over jurisdiction over the magistrate courts. So if you throw that into every district, then it means we have magistrates in Gallup, magistrate in Thoreau, and magistrates in Aztec and Farmington. So it's become a much bigger job.
Right. Well, let me ask you about the job a little bit, if you don't mind. And one of the things I wanted to ask you about was being able to not always maybe say what you felt about certain cases or certain issues facing New Mexicans. And you were telling me before we came on the air this morning that you were very cautious in what you would say and how you would say it, but you always felt like you could say what was on your mind.
Well, I think I did. I'm not shy that way. I think as a judge, it's good for a judge to be part of the community effort to be fair. And if you can't hear a case and you have an opinion so strongly that you feel like you got to say your own opinion, I think maybe you shouldn't hear that case. So I truly tried. I promised my law partner Scott Curtis that when I became judge that I would listen, and I would listen to both sides. I think my family now hates me because if they tell me something, I always ask them, well, what's the other side of the story?
Right.
Because one thing you learn as a judge is there's at least two sides to every story, and sometimes there's three or four. So you have to be really careful about getting all the way to the end. But I get to express how I feel about cases, either in sentencing or judgments. That's how I felt about the facts and how it applied to the law. I think there was occasions when someone was particularly egregious, I might say something about that. And
Right.
when somebody was not and was trying to change their lives, I would say something about that.
From the bench.
You bet.
Of course.
You bet.
But not to the media necessarily. That's another whole animal, is it not?
No, I never spoke to the media.
I'm not taking it personally at all, Judge,
No,
at all.
don't. 4 years ago, I was appointed by the Supreme Court to the Judicial Standards Commission, which is it hears all the cases and complaints against judges. I became even more acutely aware of that perception. As lawyers, we talk about the appearance of impropriety. Something that is very obnoxious in what's going on. In other words, there's nothing going on. It might appear to people that it's not really right. If I was at lunch with an attorney and that attorney was on the other side of your case and I was your judge and you saw me out, you would think you wouldn't like that. And even though nothing is going on, it's that appearance of impropriety. So we talk about that a lot as a judge. And one of the things they caution us about is talking to the media. We're not allowed, in fact, by rule, to talk about a particular case. We can certainly talk about the law, talk about the Constitution and things like that, but not about particular cases. It's really easier just not to talk about them.
And that makes sense. And I think we hear some attorneys say they don't want to try the case in the media, and ideally that would be a great way to live, but it doesn't always happen.
Well, some of them do that, but
Yes.
but
Proclaiming they don't.
No, we don't. And in a small community, the coverage that you get, I did 90% of my cases were criminal cases. The coverage that you get in a small community, quite frankly, is disappointing. The media tends to pick out the most titillating kind of cases, the most exciting. They don't talk about all the times that we take care of cases. We send people to jail. We don't send them to jail. They don't cover people successfully completing probation. I think they actually scare people to think that this is all that's going on is this murder case. That's a very small percentage of what we do. We only try maybe 2% of all the cases that come in. The rest of the cases work themselves out. The lawyers who know more about them as a judge, they come to a solution. They talk to the victims. They talk to law enforcement, and they come to a solution. And oftentimes includes jail. The media tends to go to the one that's real exciting and all of that. I don't think that's the whole deal, and I think in a lot of ways the public doesn't get the information they need.
Sure. And when they're settled without going to trial, a plea bargain or something else, right? I mean, if every case went to trial, that would overload the system, would it not?
If every case went to trial, that would be an interesting solution. Our former governor, Susana Martinez, was the district attorney in Las Cruces, and she had a policy and carried it off fairly well that you either pled as charged, I think was the deal, or you went to trial. And they tried cases every day, but they got it done. So I don't know in the long run which is better. If you can't make a decision in the case, then you should try it. I always thought if they brought something for me to hear, they couldn't figure it out. I'm not nobody made me any smarter when I became judge, so I just tried to do the best I could. When they get to that point, there aren't really answers. The same is true in a criminal case. If you can't decide if the guy's guilty or not, let the jury decide. You get 12 people up there, they'll normally come up with the answer, and I normally agreed with them almost all the time. So that's the best way to do it.
Right. And when there is a jury trial, it's really your job, I guess, to decide what the jury hears, what's acceptable to the jury, what follows the rules of the law, I guess, when both sides are presenting before the jury.
You bet. It's sort of like refereeing. The rules. If the rules are applied, a case we think is being handled fairly. So I apply the rules, but there really aren't a lot of arguments about that. Most of the time, I've tried jury trials where I really never made a ruling. I may have ruled on the jury instructions, but not on the evidence. The lawyers know what the rules are, and a lot of times there's not really controversial stuff that can come in. And it's stuff that most people would agree with. Hearsay, for example, we don't let somebody say what somebody else said that's not in the courtroom. That doesn't seem fair. You were having an argument with somebody or trying to make a decision, and they said, well, your dad told me. that's just not right. So really the rules are just common sense kind of things.
But yet sometimes you could get an appeal, right? And there could be a judge's ruling that may be suspect or looked at more closely because of an appeal that goes up to a higher court?
Sure, and there are appeals when there's nothing going on, but certainly in doing criminal cases, I guarantee you that a third of the cases I ever heard probably were appealed. Well, maybe not that many. Certainly of the ones I tried, most of them were appealed. So sure, there's an appellate court. We have a system where, a criminal case first goes to magistrate court. In fact, first the police look at it.
Right.
Then the district attorney looks at it. And then the magistrate court looks at it to make sure there's some evidence to proceed on. Then the district court looks at it. And then the appellate courts look at it, the Court of Appeals and then the Supreme Court. If it's a first-degree murder case, there's an automatic appeal. So there's a lot of checks and balances in the system. But those of us that like the law intellectually, that's the part that's interesting to us. I'm not sure it's interesting to everybody else, but we like the nuances in the law and how things change. And sometimes we've done things a long time a certain way and we all think it's right, and somebody complains and it goes up and they say, no, that's been wrong for years. That's happened several times during my career. So,
for example, could you give us one that comes to mind?
It used to be that the police would pull somebody over, they'd have suspicion to pull somebody over, they ran a stop sign. There's 7 people in the car. They would ask everybody in the car for their driver's license, their name, and run their names. There's a case in New Mexico that came up since I've been on the bench that says you don't have probable cause to talk to those other people. You only have probable cause to talk to that person. For as long as I've been a lawyer, which at that point was probably 30 plus years, we had done that. And in one case, I can't remember the name of it, starts with an A, they said, no, you can't do that.
And that changed everything from then on out.
Absolutely.
And that's how it works.
And it changed almost every case that comes up.
Right, right.
So, yeah, it was a big deal.
And with as many cases as you have presided over, and you mentioned earlier at the beginning of our discussion today how you try to look at both sides, or maybe there's more than just two sides or multiple sides, how do you stop from being jaded about cases or about criminals coming before you and things like that? Is it the positive stories that you mentioned that don't get covered to see those through?
Sure. I think you can get jaded if you choose to get jaded. So I've been doing this for 42 years. I just chose not to get jaded. I think it's interesting. I think it's an opportunity as a judge and as a lawyer to help people. Lawyers do a lot of good with people. It is attorneys and counselors at law. They give a lot of advice that can help people make changes. I always used to tell my clients, if you'd have come to see me before you did this, we could have worked out better advice for you. So a lot of that lawyers don't get much credit for, that they've talked to people, they get things worked out, and they don't end up in court. So I don't think jaded is the right word. You can get annoyed sometime, things don't go the way you want them to go and things like that, but I went down every morning with a good attitude to get through the day, and every day before I went home I stopped at the back door and I said, okay, John, what just happened in there is not the real world. It's not an unsafe place to be. That's just the part of it that you get. And I try to clear it out of my head and go home. And you can ask Gail. She knows nothing about any case that I've ever done because I chose not to talk about it when I got home.
Kept work at work.
I kept work at work.
That's great advice for anybody, I think, too, in any career, really.
It is.
But what about that fifth-time offender who shows up in front of you again for the 5th time, and you've given him chance after chance after chance, or her? Does that get a little disappointing? Maybe that's a better word.
I just get frustrated that they're putting themselves in that position. I used to ask, especially young kids that were there a couple of times, I'd say, do you like the jail? No, they don't like the jail. Well, I heard they changed it. You were going to get a TV in your own cell. The food was going to get better. It wasn't going to smell as bad. Your girlfriend can come see you. And they'd start laughing. I said, so, you don't like it, do you? And they'd go, no. I said, well, if you come back, then it's your choice to go to jail. It's not mine. I never took any pleasure out of sending anybody to jail particularly. That's not what I got up in the morning ready to do. I did it, and I did it a lot. But I don't want to. So when they would come back, they just made it easier for me to send them to, they sent themselves to jail. I just complied with their wishes. So it gets frustrating, and those are the people that normally end up in jail. DWIs particularly, I don't like DWI. I've lived here all my life. When I was county commissioner, I worked on the DWI treatment project. I knew what a devastating toll it takes on the community. I'm really proud that it's gotten better. If you look at DWI-related or alcohol-related traffic accidents, I think that number's been down for years. I hadn't heard a vehicular homicide case the last 5 years that I was judge, I bet. If I didn't hear very many. I'm pretty proud of that. Is it still a problem? It still is. But I'm really pleased that young kids They either Uber, even though you can't Uber in Farmington, but they either Uber or they get pulled over and there's a bunch of drunk people in the car except the driver's sober. That's a whole generation shift. And really the only way you can solve crime is to stop some of these trending things, that whether it's through a family system or a culture, you've got to change those. We'll never get you out of the criminal problem through the judiciary. It just fills up the jails, which they're full most of the time. It costs us a lot more money. So people just need to do better at what they do, and I tried to encourage that as much as I could.
And these generational changes that you're talking about in regards to DWI, is that something that we see in other things as well, like domestic violence? You mentioned that before. Does that tend to come around if mom and dad were fighting all the time? Is it?
Yeah, unfortunately, domestic violence. If your parents were involved in domestic violence, unfortunately, your chances of being involved in it go way up.
Right.
We do send them to counseling, and you did see some changes. That's a very hard thing to change. And what would really bother me as DV commissioner is I'd have a case. Someone would come in and they had a complaint against somebody. 2 years later, they'd come in and they'd have a complaint against somebody else, and they kept finding themselves in that victim role over and over. That's very frustrating. It's very frustrating for the police. Police are more apt to be harmed in a domestic violence situation, probably more than in any other situation. So domestic violence was a lot more discouraging to me in a lot of ways than most of the criminal cases that I did.
And a lot of those cases, you see a lot of those cases. You
Yeah.
did, yeah. Let me ask you a bit about some new, the new legislation, constitutional amendment about, and I called it catch and release before we came on the air, and you told me that's a misnomer. So,
It is.
so help me to explain it a little bit better to our audience this morning about what that means. But it's all about setting bond for folks who are accused of a crime and not yet convicted, but awaiting trial. Is that the idea?
That's right. So, I mean, the Constitution says that you're innocent until proven guilty. And in the Constitution in New Mexico, it said that that all things being equal, you should be released. But the culture of what was going on was that people had turned to bondsmen. And we had an order, and I think every district in New Mexico, and quite frankly around the country, had an order that said, if you got arrested for a first DWI, your bond was $500, da-da-da-da-da, and that was it. And it turns out there's a lot of people sitting in jail just because of money. Plus, if you think about it, then bondsmen would decide who would get out. They didn't have to bond somebody if they didn't want to. So that didn't seem like that was a good connect on who should get out. So the Supreme Court, in a case called State versus Brown, reiterated the Constitution. I don't think it said much else, but it did say, and that was a case where a guy was charged with first-degree murder. He had nothing else on his record. Pretrial services in Albuquerque said he could be released, and there was all kinds of ways to protect the public, and the judge said, I'm not going to set any bond for you. Clearly against the Constitution. They ran that case up to the appellate court, and Justice Daniels took the opportunity to recite the Constitution, and from thence came this big movement to change the rules.
Okay.
Which is now, I mean, we certainly weren't the first. The District of Columbia was the first, but now it's all over the country. Colorado's implemented it, but they're doing it all over the place. And quite frankly, not much happened. You know, there was a bunch of people that got out of jail.
Right.
And the first thing they did is they passed the amendment and gave us no other resources to really watch people. People think that if you're on probation or you're on pretrial services or you're out on bond, somebody's really watching. Nothing could be further from the truth. Probation does a better job, but they have big caseloads, and they do the best they can. Pretrial services, we had 2 people. And the county funded part of that. We had 2 people, and we were letting people out like crazy. So basically, they were signing a piece of paper saying, we'll behave and we'll come to court and go from there. The jail population, these aren't exact numbers, but I think the jail population in San Juan County went down a couple of hundred, stayed down for about 8 weeks, and went right back to where it was. They come to court. They're on drugs. They don't show up at court. I used to issue maybe 2 warrants every other Monday. I was up to 16. People were getting out and they weren't appearing. Once you violate your conditions of release, you don't have a reoccurring right to be released under that amendment. So then the same number of people ended up in jail. They just ended up with no bond. Also, there's a rule that says the district attorney can file and ask that you be held without bond, but it's up to the district attorney to file that case, and that's purely on the issue of dangerousness. If you're a danger, no bond is set. The only other thing we look at if you're not dangerous is what are the chances that you're going to appear. And there's been a bunch of interesting cases on that. I'm not sure how much has really changed in the big picture of things. But setting conditions of release I found to be the hardest thing to do as a judge. I mean, who's to know? I mean, everybody says, oh, judge, I'll show up for court, not a problem, not a big deal. It's tough, and I think that there needs to be more resources to protect the public and to help people. But in the long run, I'm not sure what the change is going to be.
And is it doing what you think the intent was from the Supreme Court about not making it a matter of status or socioeconomic status to get in or out of jail if you're accused of something?
Well, there aren't any bondsmen, so I don't know what they intended, but there aren't any bondsmen. But no, I mean, I think from my point of view, somebody who had to call these cases and try to get them done, it didn't accomplish very much to help me do that. Sure, it was always easier that they were in jail. I knew where they were, and I could call somebody, and they'd bring them over to me.
Right.
So if it's the orderly administration of justice, then no. If it's to tell people that they're innocent until proven guilty, then I think that's helped with that. But it's just not. It's not a perfect world. We don't get JoJo that comes in and this is the only time he's been charged. A lot of times he's been charged before. He might have a failure to appear. It's not as easy as the guy who was charged with first-degree murder. I think he was charged with killing his wife. Probably wasn't a threat to anybody else, and had no record, had a job. There was all kinds of things in place. It's just not like that.
Sure.
Life is not black and white. It's several shades of purple or something. I don't know what it is, but it's not easy.
And that's tossed to you to try to determine what's
Right.
black and what's white when you have a case that's multiple shades of purple.
Right, and then the district attorney has to make a decision, that hard decision. There's all kinds. Defense attorneys, sure, they want their clients out of jail. I haven't not been an attorney for so long that I don't remember the first question asked when you had a criminal case was, can you get me out of jail? That was the first question.
Right.
So,
Right.
But in the long run, I think it's a move to a better place. I think it needs some work.
And I thought the prosecutors were kind of upset with this change. Have they kind of calmed down about it now? And I suppose I could ask the district attorney that question too.
Well, I think there was a lot of 409 motions. That's to hold them without bond at the beginning.
Okay.
But that's a discretionary thing. So I think that we, as lawyers, we all settle into the rules and try to figure out what's going on with that. But if there were truly dangerous people out there, then the district attorney, I think, normally was able to keep them in jail. And I think that's what's gone on. I think the truly dangerous people are in jail by what we see. But is everybody that should be in jail? Well, I'm not so sure about that. So.
Right. And was there ever time, or maybe multiple times, that you would give somebody who was in front of you, a defendant, another chance, or let him out to go to jail or support, or to go to work and support his family, and he disappointed you and didn't show up? Or,
Sure. The study that started a lot of this actually had pretty good facts that said that even we used to think that a little jail sentence would keep you from doing it again. But actually this study showed that even a couple of days in jail made you more likely to commit another crime. If you think about it, if you're out working, you're getting by, you miss a couple of paychecks, you lose your car, lose your house, your wife doesn't come back, it actually made it worse. So that's that balancing act of trying to cut them a break and stuff like that. But for me, it was sort of especially on conditions of release with a pending case, that case needs to be taken care of for the victim and everybody else that's involved in that case. If you didn't show up once, then, I got a little suspicious about what was going on at that point. So, yeah, disappointed may not be the right word, but do you have the opportunity to see it didn't work? Yeah, you have a lot of opportunity to see it didn't work.
Right. When they do actually show up in front of you, though, does that mean that you still try to treat them the same, even though you're a little upset with them for...
Absolutely. I mean, I don't think that has anything to do with it. So I don't know how the rest of the district attorney or the defense lawyers work.
Right.
That it may have been more difficult to work with those people. I mean, the district attorney gets to make the offers they want to make, and if you're not cooperating, then I guess they get to make different decisions. But for me, it didn't make any difference to me. It might, at sentencing, it might kind of come into it. The district attorney might say, Judge, they didn't show up 3 times. I don't think they're taking this serious. Maybe they need a little jail time. But sure. That never was before guilt or innocence was determined, that didn't factor into what I thought.
Let me ask you about sentencing, because that's another part of the job that you would do as a judge, but sometimes your hands are a little bit tied because of legislation. There were sentences that would just go with the accused crime, I would say. Does that give a little bit of leeway away from a judge in determining what the sentence should be?
Well, in New Mexico, we have some mandatory minimum sentences. I never thought those were that relevant. They seem to be below, especially on DWI, what I thought should happen. So we don't have a lot of that, but the habitual offender law, which the district attorney shall file in every case, is supposed to add mandatory time. That became a big bargaining tool for the district attorney. They could say you can plead to, you have 2 prior felonies, but if you plead to this one, we'll only use one of them. not both of them. Well, if they use both of them, it's 4 mandatory years. If they only use one, it's 1 year, but it doesn't have to be served. So they're taking away some discretion there. But really, they have the right to look at those cases and make a decision about them also. I think over the years I became more annoyed about the habitual offender law than I was at the beginning. I mean, if you've got 2 prior felonies and you have a case where maybe you're guilty, maybe you're not, the threat of those 2 prior felonies is pretty big to whether you can prove yourself innocent. If the jury hears about them, they're going to think, the easiest thing for them to say is, well, you've done it before, you must have done it again. So it's kind of a tough deal for the defense attorney. I'm not sure that law has worked out the way the public thought, which is, people with prior felonies are going to go to jail or not. So I think maybe some more work on that in the future. It's like 3 strikes and you're out, I think, has been a failure in New Mexico. There just aren't that many people that qualify under that narrow law that it would apply.
Right. You mentioned DWI earlier and how much San Juan County has done in reducing the numbers of DWIs. And the one thing I want to ask you a little bit about, I think a program that you were very much involved with is the treatment center, the jail and treatment center, and the 28-day program. And that really, I think, has its success on the inclusion of judges in the community who would sentence folks to that program. Is that something that is a positive thing when we look back on it?
Well, I think it is. I mean, we started that, Judge Anuska was judge, and I was on the county commission, and we got together with a bunch of other people, including the mayor at the time, Tommy Taylor, and it was .08 will get you 28.
Right.
And that was we were the only place in the country that were willing to do that. Judge Lease actually enforced it for many years, and I think it's had its desired effect. I think some people don't get that sentence, but most of them are told by their lawyers, you better go get an alcohol treatment, or this judge is going to put you in jail for 28 days. So did that work? Yeah, probably that worked for the same way. I haven't seen the numbers on that program recently, but I know early on it was studied by UNM, and the numbers were doing pretty well. I think it's harder with people, for the public, is the guy who gets 7, 8, 9, 10, 11, and 12. And I always used to hear, why aren't they in jail? Well, for years, a first DWI was 90 days, a second was 364, the third was 364. A fourth was 18 months, a fifth was 2 years, a sixth was 2.5, a 7 was 3, an 8 was 3, a 9 was 3, a 10 was 3, 11, 12, ad infinitum. Wow. It never went above 3. Now that got changed as I went out, but it's the legislator sets the penalty. Judges can only go within those penalties, but I had a lot of issues about, if we waited till a fourth was a felony. I think in Texas a second is a felony. I think the hammer needs to come down sooner rather than later. And our magistrates courts up here did a better job on second and thirds, and I think that's contributed a lot to slowing it down, because they would impose 6 months on some of those, and I think people had a wake-up call that we weren't going to put up with this. So why aren't they in jail? Well, we don't have life sentences for DWI. So.
Right. Well, I know there was a lot of concern, too, if someone was a breadwinner for their family and they were sentenced to this 28, even the 28-day program, it would cause a hardship, some would say.
Yep.
And so is this an example, though, of how judges can work with community members to try to solve a problem in different communities, and not leave it up to the state legislature?
I think so. I mean, San Juan County is a great place to live in that sense. They not only did the DWI program, but years later we did the Access program, which is for female drug offenders. We also started the domestic violence program. A lot of that was at the initiative of Judge Anuska. So sometimes you have to do what you have to do. I read one time that politics is always more responsive the closer it gets to home. So, if you're
all politics is local, something like that.
Yes. Chris Matthews' book, yeah.
Right.
So, if you're a congressman in Washington, you're not very close to your constituency. But if you're a county commissioner in San Juan County, you're pretty close to your constituency, or a municipal judge and things like that. So I think it's better that way. And luckily, we had the resources up here to apply to those programs. I think we did a lot of good. We can't stay stagnant, though. I think you have to keep looking at them. Now I'm told that we're moving away from meth, more back into heroin. Heroin's cheaper. It's showing up more and more. I went years and wouldn't have a heroin case. Now, even when I was getting ready to leave, there was a lot more of them. So, you've got to keep moving and trying to see what you can do to address these problems. It's a lot more cost-effective to attack the problem early than it is late. We spend so much money on people that really we've missed our opportunity to make much of a difference in their lives.
Sure, and we've seen some of that with some of the more recent programs like the Sobering Center and some other programs that, again, aren't just funded by one entity but by a combination to try to do something for our community.
Total Behavioral Health, I'm a big fan of. I think they do a great job over there trying to get into the cultural issues and really being responsive to that. If I knew what kept people from getting DWI again or to quit drinking, I wouldn't be here. I'd be phoning this in from someplace that's really expensive to live. But whatever works is what works. And so a lot of opportunities to quit is what you ought to give somebody or have available. If they don't take advantage of them, they ought to go to jail.
Judge Dean, we're almost out of time this morning, but I appreciate you being here. Is there any news about what's next? You resigned from the bench, but you're still busy, I know. And what are your thoughts?
Well, retirement's the ugliest word in the English language. So
I didn't want to use that other R word with you, so no, I'm trying to avoid it.
I have no intention of doing nothing. So, plus I can't get Gail to retire, so she has no intention of retiring.
We don't want her to here at Samuel College.
That's right. So I guess as long as she's up here, I'll keep doing something. But I guarantee I'm not at home watching soap operas. So.
Well, that's good to know. That's good to know. Maybe you see your name on a ballot somewhere in the future?
I think I'm over that. I ran the first
you were
time in
county
88.
Commissioner. Yeah.
I ran in 88. I ran in 92. I ran in 96. I ran in 04. I think I'm kind of over that, but who knows what I might do.
Okay. Well, I know it'll be great. So thank you for your time.
Hey, thanks for having me.
You bet. Judge John Dean, my guest here on KSJE. Did you enjoy that podcast? We hope that you did. And if you did, share it with your friends. And if you really want to keep podcasts like this coming, please support KSJE. You can do it easily online at ksje.com.